Court has heard the testimony that's been presented today. I have reviewed the pre-sentence investigation, heard the comments of counsels, and observed the exhibit. The court also takes notice of its probable cause affidavit and all the contents in its file. Court would enter, as of today's date, a judgment of conviction for count 2, aggravated battery, a level 3 felony, and count 3, aggravated battery, a level 3 felony. Count 1 is dismissed. And Mr. Perez, the court has to look at aggravating and mitigating circumstances. Those encompass looking at the protection for the public, the seriousness of the crimes, and your rehabilitative needs and character. So that's when I look at those type of aggravators and mitigators, that's what I'm putting them around. Court would note, as noted by counsel, that under Indiana Code 3550.12 sub A sub 8, aggravated battery is considered a violent crime. Under the same code, but under subsection C, they may be consecutive to one another, so that everyone's aware. Level 3 felony is punishable up to 16 years in prison. There's 9 years as an advisory, so if the court issues anything that is above 9 years, I have to give reasons why for doing that. So number 1 to George and Jennifer, I'm very sorry you're here. I'm very sorry for Kingston and what he has to go through, what he did go through, and what his life could be like if this had not occurred. So I take notice to that. He was 3 when this happened. He doesn't really get the ability to come up here and say what he thinks, what he feels, what he thought. He was an absolute innocent, 100%, who didn't deserve this. He just didn't. And you have changed his life forever from what it could have been. When I look at the seriousness of the crime, it does not get much more serious than this. It's been alluded to here today. It's not Mr. Perez who's lucky, it's Kingston who's lucky that the bullet didn't take his life. I don't consider that your luck. It never should have happened. And I would hope and I believe everybody here is thankful for that. Mr. Perez, I'm glad you were not injured any more than you were at all. I can't imagine holding your child and being shot at by your brother. So obviously the crimes are very serious. In regard to the remainder, we have a criminal history. There are 7 criminal convictions, 2 misdemeanors, 5 felonies. That includes criminal mischief, theft, 2 resisting law enforcement, receiving stolen property, and attempted burglary. He did serve time in the Indiana Boys School as a juvenile. He's been on home detention and had that opportunity. He has spent time in jail and he has served prison time. He was given the opportunity of probation 3 times. He had 10 petitions to revoke filed, meaning he was not complying with conditions. He violated them at least 7 times, and he was unsuccessfully discharged 2 out of the 3 times on probation. I know on page 11, and then some of the testimony here today, page 11 of the PSI, Mr. Perez states he's always been denied opportunities for treatment in the criminal justice system. That's simply not true. He was ordered back in April of 2001 to do Thinking for a Change. November of 2002, a tutoring program, wildlife program, complete a psychological evaluation. October of 2003 to complete Quinco. January of 2008, a substance abuse evaluation. June of 2010, a matrix program was offered to him. Whether or not he took advantage of those, nobody is responsible for except you. At the plea hearing, when I did ask him if he was a drug or alcohol abuser, he stated yes. If I asked if he was hoping to receive treatment, his answer was no. His testimony today does not give me any hope that he would receive or be open to that, which is really unfortunate. Because if you have issues that you need to deal with and you are not open to dealing with them from experts who can assist you, then you're putting the rest of the community in danger. You're putting yourself in danger. And if you're not willing to do that, then the correct place for you is in a structured placement. He has a pending Johnson County case for resisting law enforcement. What was the result of him pleading the day after? That is 41 DO1 2306 F6416. There's a warrant out on that case. At this time, that's an aggravator. Sometimes we look for accepting responsibility and or a lack of remorse, or if they have remorse. I can't tell. I really can't tell. The only time you cry is when your girlfriend testified.
I cried whenever I was talking to my brother and stuff. And I didn't cry when she was testifying. I was cried whenever my brother-in-law was testifying.
Stop. What's interesting is when you ask people what they remember during that day. So we have someone who got up, went to work. Mr. Frosch said he went to work a lot. I mean, he would do that, sometimes working 60 hours a week. But within at least the last couple months, was different. So he gets angry because Ms. Frosch is not answering the phone. She already knows that he's going to be mad, but she tells me something. I don't know about the rest of you. But there's a pattern and a problem. So there's an argument. He smashes a TV. That does not bode well for community safety or personal safety for someone who's around him. Gets in a car and thinks the first thing to do that'll help him is to drink alcohol and intake marijuana, and then drive in our community. So how many other people were at risk that day? And for how long? And where? Which other families and kids were out there? But he has enough recollection to remember he went to a park to think about it, and just to, not about it, but think. I don't know about what. What would make you get back in the car, go to your brother's house, and shoot through a door where 9 other people are at? He had to have seen his brother. It was a glass door. He had to have seen there was a child in his hands. Yet he doesn't recall, and he doesn't want any help. That is a dangerous person.
Your Honor, I didn't answer the door with a child in my hand. Just to make that clear.
Thank you. Okay. Then I correct that. I thought you were holding him at the time. Five bullets. 2 hit George, and 1 hits Kingston. He's under 12 years of age, so that makes that an aggravator. He gets shot in the head. And again, a 3-year-old, not going to have any idea what's going to happen or what's going to go on. None. And this is his uncle. Someone who's saying that he was going over there more trying to get closer, if not, was already closer. And from what we know now, no reason. That does not make sense. He shot into a home where there were other children in the living room that he shot into. The bullets ricocheted. That caused a serious danger to other children and people as well. That's an aggravator. Kingston had to go undergo neurosurgery. He now has a prosthetic plate in his head. He has to continue to go through therapy. He has a speech problem. His right arm does not work real well. He can't open his hand all the way. He walks with a limp. He had 3 surgeries. He was in a coma for a significant period of time. He was in the hospital for 2.5 months. He may need more surgeries. He was in a coma, as I know, for at least one month. And the one thing that is good was nice to hear you say that he's a fighter. And you can see some of his personality coming back, and he's still here. And for that, we're thankful. But the injuries to him and using a firearm are elements and facts greater than that needed to prove any of the elements of counts 2 or 3. Those are aggravators. As well as the harm to the other children who were within the living room. In addition, they were not related to this crime, they are not victims, so that also is an aggravator that he placed them in extreme danger. He then fled the area and drove again until found the next day. That is an aggravator. It also would unduly depreciate the seriousness of the offenses if the court did not impose a prison term. The court saw 2 mitigators. He did plead guilty, and his last conviction was in 2008, so there's been a significant period of time between that and when this offense occurred. The court gives those little weight. He's pleading into counts 2 and 3, level 3 felonies. Count 1, level 1 felony is dismissed. The court also believes that the substantial evidence against him was strong, and the court is concerned regarding his lack of memory, which someone comes across as a lack of responsibility or lack of remorse as well. The aggravators far outweigh the mitigators. In regard to count 3 for Kingston, the court is going to order that he serve 16 years to the Department of Corrections. In regard to count 2, that will be executed. He will serve 16 years consecutive to the Department of Corrections. He will execute 13 years. 3 will be suspended to probation with community corrections. Court will recommend a mental health and substance use placement. Court is not ordering RWI. If he's going to do treatment, which he told me here he doesn't want to do, and he ever wants to file a motion to modify, he's going to have to show that he's actually doing it. If he doesn't, there will be no change. Court also believes a 3-year period to transition back into the community, and again, keep an eye on the ability, hopefully at that time, to make sure he's in some type of counseling or has some structure around him would be important to place him back in the community. There are court costs in the amount of $189, administrative probation fee of $100, initial probation fee of $100, monthly fee of probation for $30 during the 2nd month, and every month thereafter $100 public defender fee. Did either party wanted to address costs?
Judge, given the fact that my client will be spending a substantial amount of time in DOC, we would ask the court, plus the fact that he's currently incarcerated, to find him indigent, any kind of fine and costs that are within the court's discretion.
Nothing from the state, Your Honor.
What the court is going to do is leave him in place at now, and he is out on probation. If he is unable to afford those costs while he's on probation, the court would entertain a motion to reconsider at that time. Is the state asking for a restitution hearing? Or do you want to notify the court within a week or so whether you're going to need that? Because we can't hold that out too far. If that's
Yes,
what the parties want to do.
I can notify the court and Mr. Villanueva within 7 days, if that's going to be necessary.
And what's his credit time as well?
Yes, thank you. He has credit time of 615 days from June 3rd, 2023 to February 6th, 2025. Thank you, Phoebe. The state is prohibited from filing charges under Bartholomew County Sheriff's Office Report numbers 2024-00073. The state had also agreed not to file a firearm enhancement. The court has stayed within the bounds of the plea agreement. My understanding then from that agreement is he has no right to appeal. Is that correct, Mr. Villanueva?
Given the court's sentencing, we would agree, Judge.
Ms. Sexton Yeager?
I agree as well.
He will be remanded to the Bartholomew County Jail, where he will then be transported to the Department of Corrections. Anything further, Mr. Villanueva?
Not in the defense, Judge.
Anything further, Ms. Sexton Yeager?
No, Your Honor, thank you.
That's all the no contact orders on those ones.
I'm not
Yes,
worried about
please.
it.
The no contact orders will be
Tell me, hey, keep your head together, bro. They're waiting for you.
Love you guys.
And this was 16.
Second.